There was a pink backpack on the clerk's table. One zipper was broken. A paper star hung from the handle by a thread that had started to fray. I still think about that backpack because it was the only thing in that room that looked like it belonged in a second-grade classroom, not a courtroom. I saw it before I saw her, before I heard a word of testimony, before I read the phone records into the record, before I looked at the traffic footage again. I saw that backpack and thought someone had brought the wrong thing to court. I was wrong. They had brought the whole weight of home into that room. Subscribe to this channel. I do not say that lightly. I say it because if you are still listening at this point, you are exactly the kind of person who should hear what comes next. Subscribe, then I will keep going. Daniel Reyes came into my courtroom first. He was 38 years old. He wore a clean white shirt, gray work pants, and boots with drywall dust still caught in the seams. He used a cane, but before he sat down, he bent over and fixed the cuff of his daughter's sweater. That told me something about him before he ever spoke. He did not present himself like a man asking for pity. He answered questions directly. If he did not know a number, he said he did not know it. If he remembered one later, he corrected himself. I noticed that. I always notice that. People tell me who they are long before they mean to. His daughter, Sofia Reyes, was 7. 2 braids, one tighter than the other. She held that pink backpack with both hands like it was part shield and part anchor. She did not fidget. She did not whisper. She watched every adult in that room the way children watch the sky before rain. Andrew Mercer came in after them, 26 years old. Navy blazer, no tie, expensive watch, car key in one hand, until the clerk asked him to put it away. He walked quickly, then slowed when he realized the room had already turned toward him. Before he sat, he looked at the second row where his parents were sitting. That look stayed with me. When he thought nobody important was watching, he pressed his thumb against the edge of his watch band again and again. During testimony, he sat up straight. During breaks, his shoulders dropped. I do not say that as judgment. I say it because behavior matters. I sit high enough to see what people do when they forget they are being seen. The file told me the incident happened on Friday, March 8, 2024 at 6:42 p.m. at Dorrance Street and Washington Street in downtown Providence. It had been raining on and off all afternoon. Daniel Reyes had finished a maintenance shift and was walking home from the bus stop with milk, bread, and a small tool bag. Andrew Mercer was driving a black 2023 BMW X5. The city camera showed him making a right turn into the crosswalk. The state said he was looking at his phone when he came through the turn. The defense said Daniel stepped late and wore dark clothing in the rain. I heard every version. I read every report. By the time the case was in front of me, I knew the scene almost the way a person knows a place they were never actually standing in. In Officer Carla Mendez's report, one line was underlined in my notes. Andrew Mercer said, "He came out of nowhere." Later on body camera, he said, "Can somebody call my father before this gets out of hand?" I do not forget lines like that. Not because they prove everything, because they show me what a person reaches for first. If you are the kind of person who stayed with this story this far, not because it is dramatic, but because you actually want to know what happened, then you already understand why I am telling it. Subscribe. This is what I do now. Tell the stories that need to be told. By the time the matter reached my bench, it was no longer a simple traffic case. Andrew Mercer was charged with reckless driving causing bodily injury, operating a vehicle while using a handheld device, and failure to yield to a pedestrian in a marked crosswalk. Daniel Reyes had a fractured pelvis, torn ligaments in his left knee, and nerve pain that followed him home. There is something most people do not know about cases involving children. Before I let a child testify, I do not begin with the case. I begin with truth. I ask what truth means. I ask what a lie is. I ask what happens when somebody lies in a courtroom. I am not testing school knowledge. I am testing whether the child understands weight. That issue came across my desk before the third day of testimony. The state wanted to call Sofia Reyes, not because she saw the crash, but because she could speak to what happened in that home after it. The defense objected. I understood the objection, and I still knew I had to think carefully, because some facts live after the ambulance leaves. On the first morning of trial, Daniel Reyes entered through the side door with that cane in his right hand and Sophia 2 steps behind him. He did not look across the room at Andrew Mercer. He looked at the chair, then at his daughter. Sophia looked up at me one time on the way in like she was deciding whether I was safe. Andrew Mercer came through the main door with his lawyer, Thomas Keene. His father carried a leather folder. His mother sat very still before the hearing even began. Andrew looked toward the Reyes family only after he was already seated. It was a quick look, not apology, not anger, more like discomfort at seeing the result still there in front of him. The first wave of evidence set the baseline. Officer Mendez testified to the scene. A paramedic described Daniel Reyes asking for his daughter before he was loaded into the ambulance. The traffic camera showed the crosswalk signal change to walk, then Andrew Mercer's vehicle coming through the turn. Nothing in that footage was theatrical. That was why it carried weight. I noticed Elena Reyes, Daniel's sister, in the second row with Sophia. While the video played, Elena had one hand on the child's shoulder and the other wrapped around the broken zipper of that backpack so tightly that her knuckles went pale. I remember that more clearly than I remember half the arguments that day. Then came the timing evidence. The crosswalk signal had changed 3.8 seconds before Daniel stepped off the curb. The speed limit was 25. The reconstruction officer put Andrew Mercer at 37 before braking. Precise numbers matter. They do not always make a case bigger. They make it cleaner. Daniel Reyes testified that afternoon. He said, "I do not need him to feel sorry for me. I need him to understand what mornings look like in my house now." He said it quietly. Then he told me how long it took him to get from the bed to the bathroom after surgery, and how his daughter had started standing outside the door because she was afraid he would fall. The second wave complicated the case, as real cases often are complicated. Thomas Keene argued that rain, glare, and dark clothing mattered. He brought in an accident consultant who said Daniel may not have looked left a second time before entering the crosswalk. He reminded me that Andrew Mercer stayed at the scene and called 911 within a minute. That was true, and I gave it the weight it deserved. Then Marisol Vega, a barista from the corner coffee shop, took the stand. She had no connection to either family. She said, "The man was already in the crosswalk. He was not running. He was just crossing the street like people do every day." I have never forgotten that sentence, not because it was dramatic, because it was plain. The phone records came in at the end of the second day. They showed that at 6:42:09 p.m., 2 seconds before the car crossed into the marked walk, Andrew Mercer's screen lit with a text thread from Mom. At 6:42:11, the phone registered a touch. No full reply was sent. But the screen had been opened. That mattered. At the scene, Andrew Mercer had told Officer Mendez, "I looked down for 1 second." He said it again on the stand later. Same words, same calm tone. Still wrong. 1 second in a moving vehicle is a long distance. 1 second is enough time to enter a crosswalk and change a family's year. I have told this story before, to colleagues, to my family once, and every time I get to this part, I go quiet for a second. Subscribe to this channel if you want to hear what comes after the quiet. I promise it is worth it. On the third day, before the room fully settled, I had Sophia Reyes brought a little closer to the bench. I asked her if she knew the difference between truth and a lie. She said truth is what really happened. Really, a lie is when you say something happened and it did not. I asked her what happens when people lie in court. She said it makes it hard to fix things. Then I asked why she wanted to speak. She put both hands on top of that backpack and looked at me without blinking. She said, "My daddy cries every night." I did not answer right away. I set my pen down very slowly. The courtroom had gone still in the way rooms do when a child says the one thing every adult failed to say correctly. I asked her because I needed it clear on the record. "What do you mean?" She said, "He thinks I am asleep, but I hear him." Then she said, "He says his leg burns and he says he is sorry because he cannot pick me up anymore." That was not evidence of the crash itself. It was evidence of cost, real cost, the kind that lives in a hallway after midnight. The defense objected to part of that testimony, and I sustained what I needed to sustain. A courtroom must still be a courtroom. Feeling does not erase rules. But within those rules, I had heard enough to understand the reach of what happened at 6:42 p.m. on that rainy Friday. Thomas Keene defended his client fairly. He argued that Andrew Mercer had no criminal record, had cooperated, had remained at the scene, and had already offered through counsel to contribute to medical expenses. He said the state was trying to turn a single act of poor judgment into a full account of a young man's character. I listened carefully. Fairness requires that. Andrew Mercer testified in his own defense. He said, "I was not drunk and I was not running from anybody. I was late. That is not a crime." I wrote that down. Later, he said, "I looked down for 1 second. I wrote that down too." Then, during cross-examination, he said, "I never meant to hurt a working man. I just did not think it would be that serious." I wrote that down as well. I did not need to speak over any of those lines. They stood on their own. Intention matters, but so does the failure to think. A marked crosswalk is not a place where carelessness gets to call itself small. There was one moment in that trial when my own life entered the room. When I was a boy, I came into my family kitchen late one night for a glass of water. My father was sitting at the table in his undershirt. The coffee in front of him had gone cold. One hand covered his face. He was not making a sound. He thought the house was asleep. I remember the radio low on the windowsill. I remember backing out of that kitchen because I did not know what to do with the sight of a grown man trying not to be heard. I never told him I saw him. I never forgot it. Some memories do not leave because you ask them to. Subscribe if this is the kind of story you want more of. That is the whole pitch. No speech. Just subscribe if it is for you. By closing arguments, I had made my decision. In truth, I had made most of it the night before, after I reviewed the phone records again and reread Daniel Reyes's treatment summary. But a decision in my head is one thing. A decision spoken aloud in a full courtroom is another. The room changes when the law becomes part of a person's future. Andrew Mercer kept his eyes on the edge of the table. Daniel Reyes had his hand resting over Sophia's backpack strap. Sophia leaned against her aunt, fighting sleep. I read the verdict plainly. Guilty of reckless driving causing bodily injury. Guilty of operating a vehicle while using a handheld device. Guilty of failure to yield in a marked crosswalk. The first reaction I noticed was not from either lawyer. It was Sophia Reyes placing her hand on top of her father's wrist. She did it like she was the one steadying him. Children do that sometimes. They step into jobs they should never have to learn. I am telling you this story because I believe it needs to be told. Subscribe if you believe the same thing. That is all I am going to say about it. Sentencing was harder than the verdict. The law gave me range. That is what makes sentencing serious, not the chance to speak, the duty to choose. So I spoke to Andrew Mercer directly, and I said exactly what I meant. I said, I am sentencing you to 180 days suspended and 3 years of probation. You will not serve that jail time unless you fail the conditions I am imposing today. I am doing that because punishment by itself is not enough here. You need structure, limits, and work. I said, I am ordering you to pay a fine of $15,000 to the Rhode Island Trauma Recovery Fund. I am not choosing that number to make noise. I am choosing it because injuries like this leave costs behind them long after a cast comes off. I said, I am suspending your driver's license for 30 months. For the first 18 months, there will be no hardship license. You may not drive your own vehicle, a family vehicle, a company vehicle, or any borrowed vehicle. Driving is a public trust. You broke that trust in a crosswalk. I said, I am also ordering 200 hours of community service with patient transport and rehabilitation support at Rhode Island Hospital and 40 hours speaking at approved driver safety programs. You will tell the truth about what happened. You will say you looked down. You will say what that second cost. Then I said, and there is one more thing. Within 30 days, you will return to this courtroom with a written statement of apology. You will read it aloud in open court. Then you will read that same statement at the first 3 safety programs where you are assigned to speak. Private habits brought you here. Public accountability belongs here too. I was not done. I said, you are also ordered to pay all unreimbursed medical expenses related to Daniel Reyes's injury for 2 years from today, including physical therapy, transportation when needed, and the installation of the shower rail and front step ramp recommended by his therapist. Those are not optional comforts, they are what he now needs in his own home. Then I looked at him and said what I needed him to hear. I said, "You did not just break bone. You took wages, sleep, movement, and ease from a home that was already carrying enough. Your family did not do this, but they will live near it. That is what harm does. It spreads." I said, "Privilege is not only having more. Privilege is believing that your mistakes will remain manageable because they always have before. When you are given that kind of room in life, your duty is greater, not smaller." Then I gave him the last sentence. "I believe you can become better than the man who made that turn, but only if you stop defending him." Thank you for staying with this. I mean that. I know this is a long story. I know it is not easy. Subscribe if you have not yet. You already know why you are still here. When the hearing ended, I stayed on the bench signing the order while the room slowly began to move again. Daniel Reyes did not stand right away. Sophia turned to him and said something too soft for the microphone to catch. He kissed the top of her head and shut his eyes for 1 second. Not long, long enough. Andrew Mercer crossed halfway toward the Reyes family, with his lawyer close enough to stop him if needed. He said, "I am sorry, Mr. Reyes." Daniel looked at him and said, "Be on time with the therapy bills." That was all. I respected that answer more than any speech he could have made. As the courtroom emptied, Elena Reyes struggled with the broken zipper on Sophia's backpack. Andrew Mercer's mother stepped forward, held the bottom of the bag steady for a second, then stepped back. No one thanked her. No one needed to. When I finally stood, the room felt less like relief than accuracy. An appeal was filed. The Rhode Island Superior Court heard it on June 18, 2025. The sentence was affirmed in full. The court said the conditions were tied directly to rehabilitation, deterrence, and the measurable harm suffered by Daniel Reyes. It took a little over 10 months. I was not surprised, but I was relieved. I learned what happened later through compliance reviews, receipts, and the small human details that find their way back to a judge. On March 12, 2026, Andrew Mercer returned for a probation review. He arrived early. He carried a binder with every therapy payment tabbed by month. The hospital supervisor had written that he completed his service hours and then asked if he could keep volunteering on Saturdays. Daniel Reyes came in without the cane that day. That is the first thing I noticed. Not a perfect stride, not an easy one, but no cane. When I asked whether the payments had been made on time, he said, "Every one of them." Then he paused and added, "My daughter sleeps through the night again." I wrote that down too. As they were leaving, Sophia picked up the same pink backpack. The paper star was gone. Only the thread was left. She looked back once and said, "He only cries when it rains now." I did not decide in that moment what that meant. I only knew it was true, and that truth had traveled a long road to get there. The question this case left me with is one I still do not know how to answer cleanly. How much of a child's burden begins before the law ever notices it? Sophia Reyes did not become watchful in my courtroom. She arrived that way. The sentence did not create peace from nothing. It interrupted fear that had already been living in her home. What I learned is that harm does not stay where it starts. A driver looks down, a body is struck, but the impact does not stop at the street. It moves into bedtime, bathroom doors, bus schedules, paychecks, and the way a child listens through walls at night. I see that pattern more often than I wish I did. If you are someone who knows the feeling Daniel Reyes carried into that courtroom, then you know it is not only pain, it is the shame of needing help in front of the people you most want to protect. It is trying to sound normal while your child learns you're suffering by sound. I saw that in his face. I know some of you know it too. And if you are more like Andrew Mercer than Daniel Reyes, I say this without anger. What on that screen was worth entering another family's life for the next 2 years? If you do not have a good answer, put the phone away before the car moves. Make one better decision before your habits make one for you. I come back to that pink backpack, the broken zipper, the missing paper star, the way Sophia kept one hand on it whenever the adults in the room started speaking in long sentences. That is why I told you this story. If you want to hear the others, and there are others, subscribe. That is all I am asking. Subscribe and stay. And the comments are where people who care about the same things usually find each other,